Most lawyers tell you not to text and drive. Here's what actually causes more crashes than you think. Have you almost gotten into an accident on the 405 in California because you were reaching out for your phone? Or maybe a coffee cup rolled under the brake pedal, or a hair clip popped off your head, or you had an unsecured dog in the back seat. I'm Sean Chalaki. I'm a trial lawyer at GoSuits, and today I'm walking you through the everyday objects inside your car that create real liability and what California law says about them. Most of the crashes we see at GoSuits don't involve drunk drivers or commercial trucks. They involve someone who glanced down for 2 seconds, someone who reached for a water bottle, someone whose flip-flop caught on the brake pedal on the 405 during a rush hour. These are the things that we see over and over. We are covering 4 things today. What objects create the most risk? What the law requires? Who's liable when something goes wrong? And what you do in the first 72 hours after a crash. 5 seconds off the road and on your cell phone at 55 miles per hour covers the length of a football field. In 2022, distracted driving killed 3,308 people in the United States. Most of those cases involve the phone. California addressed this directly. Vehicle Code Section 23123.5 says you can't hold and operate a wireless device while driving, period. The only exception is if the phone is mounted on your windshield or dashboard, doesn't block your view, and you're using it hands-free. You can do a single swipe or tap to activate a feature. That's it. Here's the part that matters in a crash. When you look at your phone for 5 seconds at 55 miles per hour, your car travels the length of a football field. You're not watching the road. You're not reacting to brake lights. You're not seeing the pedestrian in the crosswalk. On the 405 or the 5 near downtown LA, the 5-second gap is enough to rear-end 3 cars. For civil claims, meaning someone sues you or you're suing someone else, phone use at the time of crash is a textbook breach of duty. We subpoena phone records constantly. Those records show whether the driver was on a call, sending a text, or scrolling Instagram at the moment of impact. That evidence changes cases. It changes settlement offers. It changes juries' minds. And it's not just the phone anymore. Smartwatches, dashboard touchscreens, GPS units, all of these create the same cognitive distraction. California law was updated in 2017 to cover electronic wireless communication devices broadly. If you were hit by someone staring at their wrist or fumbling with their car screen, that is still distracted driving under California law. This clip created a 6-figure liability problem for a defendant. Do you drive like this? Let's talk about hazards people don't tell you about. Hair clips, coffee cups, a bag of groceries in the back seat. It's not illegal to drive with these things. There is no California statute that says you can't adjust your hair or drink coffee while driving. But here's what the law does say. You have the duty to drive like a reasonably careful person. If you're applying mascara at 65 miles per hour on the 101, you're not meeting that standard. Here's where physics comes in. An unsecured 20-pound suitcase in your back seat becomes a 600-pound projectile in a 35-mile-per-hour crash. A laptop, a gym bag, a toolbox. If it's not strapped down and you stop suddenly, it's flying towards into the back of your head or into your passenger. We have seen this. It's not hypothetical. And before the crash even happens, that same loose object can roll off the seat, slide under your brake pedal, or distract you badly enough that you drift into the next lane. I had a case where the defendant's hair clip fell on the floor. She reached down to grab it, took her eyes off the road for 2 seconds, rear-ended my client who was in the car in front of her. My client had neck surgery. The hair clip created a 6-figure liability problem. Hot liquids are worse. You spill hot coffee in your lap, your body reacts. You pull away from the burn, you grab a napkin, you jerk the wheel. That instinctive reaction can cause a crash in the time it takes you to blink. If this spill was caused by a defective lid from a drive-thru, you might have a product liability claim on top of a negligence claim. Driving like this is one of the worst things you can do. Flip-flops, high heels, bare feet. None of these are illegal in California, although flip-flop with socks should be. But studies shows they all reduce your ability to modulate brake pressure. A flip-flop can catch on the edge of the brake pedal during emergency braking. That half a second delay is the difference between stopping in time or crashing into the car in front of you. If a crash reconstruction establishes that your footwear impaired your braking response, that's evidence of negligence. The question becomes whether a reasonable driver would wear those shoes at highway speed. Whether you're on the 101 in Los Angeles or the 91 through Orange County, every fraction of a second in brake response translates to feet of stopping distance. The duty to maintain control of your vehicle includes managing what's inside it. Let's not forget about our furry friends. An unrestrained dog in the front seat, a cat loose in the cabin, a dog that climbs into your lap while you're driving. California doesn't require pets to be restrained, but if your dog blocks your view, presses against the gear shift, or distracts you badly enough to cause a crash, you're liable. Same goes for passengers. California law requires children to be in proper restraint based on age, height, and weight. If you let your kid unbuckle and climb around the back seat and then you cause a crash because you were reaching back to grab them, you have compounded a legal violation with a safety failure. Adult passengers can create hazards too. A passenger who grabs the wheel, who distracts you with an argument, who suddenly gets sick, all of those goes into the factual record when we are analyzing who's at fault. Can you take the sun to court for blinding you while driving home on the 10? Sun glare, rain, road debris can all turn routine drives dangerous every single day. In Southern California, east-west corridors like the 10 and 91 face direct sun glare during morning and evening commute. Drivers squint into the blinding lights. Some shield their eyes with their hands. Some drive at full speed and hope for the best. Here's the legal reality. Sun glare is a foreseeable hazard. You're expected to account for it. Slow down, increase your following distance, wear sunglasses, adjust your visor. If you proceed at normal speed through blinding glare and rear-end a stopped car, the sun is not a legal defense. California courts have held this consistently. You had the duty to adapt to the conditions you were facing. Rain creates its own problem. After a dry period, which is most of the year in Southern California, the first significant rain causes oil on the road to rise and create a slick film. That's the most dangerous road condition we have in Los Angeles. Drivers who don't reduce speed when the road is wet face the same negligence analysis as drivers who ignore any other hazard. Road debris is a multi-party problem. Something falls off a truck. You swerve to avoid it and hit another car. Who's liable? The driver who lost the debris? The driver who swerved? Maybe Caltrans if the debris was reported and not cleared. We trace liability to its source and pursue every available defendant. Drowsy driving and prescription medication impairment also creates liability. If you fall asleep at the wheel or drive while taking medication that carries a warning against operating a vehicle, you have breached your duty of care. Phone records, work logs, witness statements, we use all of it to establish what actually happened. And here's the rule that controls all of this. California uses pure comparative fault. If you're found 20% at fault for a crash and your damages are $100,000, you recover $80,000. You're not barred from recovering even if you shared some responsibility. The defendant has every incentive to argue you were partially at fault. That's why documenting the other driver's distraction early through police report, witness statements, phone record is critical. Have you almost hit a car while liking that baddie's post on Instagram? We had a client a few years ago who was rear-ended at a red light on the 73 in Irvine. The other driver said our client stopped short and blamed them for the accident. We pulled the other driver's phone record. Turned out he was scrolling Instagram at the time of the impact. Never even saw the red light. The insurance company initially offered $15K. We took the case to litigation. Once we showed them the phone records, the case settled for significantly more. Bottom line, the other driver didn't think he was distracted. He thought he was just checking his phone at a stoplight. But the light turned red. Our client stopped and he didn't. That's how these crashes happen. The distraction feels minor until it's not. Save those likes for when you're not behind the wheel. the baddie can wait. Simple as that. Case closed. If you were injured in a car accident in Los Angeles, Irvine, or anywhere in California, we offer free consultation and we work on contingency, meaning you pay nothing unless you win. If this was helpful, subscribe to our channel. We publish informative videos weekly. And if you've got a question I didn't cover, drop them in the comments, I'll read them and I'll answer.